Hello and welcome to Chetan Bharat Learning, and this class we're going to cover current affairs for polity from 11th of December to 17th of December. Alright, so there were some interesting developments this week which afford us a decent opportunity to take these topics to their logical extreme and sort of prepare them from a very syllabus point of view. Alright, so the three topics that we're going to cover today is first is the legislative privilege. Alright, what are legislative privileges? Where do they fit in with the wider constitutional scheme that we have? Right, we're going to do that. Then we've heard recently that there's very less likelihood of there being a winter session or a special session, and in fact that the budget session might be preponed a little. So we'll put that into a context. All right, and then there is some chatter about delimitation. We're going to deal with that also. All right, so let's begin with legislative privileges. All right, so why is this in news at all? All right, so what happened was that the Maharashtra Assembly, the Legislative Assembly, issued a contempt notice against Arnab Goswami, asking him to stand in front of the assembly so that they could sort of quiz him or inquire about his comments. Right, what were those comments? He made certain comments that were deemed derogatory by the assembly, and these comments were against very senior politicians like Sharad Pawar and some people from other parties like Uddhav Thackeray and all of these guys. All right, so the assembly wasn't very pleased with these comments, and then Arnab Goswami approached the Supreme Court because he thought that there are going to be penal consequences, and the Supreme Court under Article 3 approached the Supreme Court under Article 32, and the Supreme Court under Article 32 then issued a notice to the Maharashtra Legislative Assembly seeking their opinion of the facts of this issue. All right, now what did Maharashtra Assembly respond as? Right, and that's going to be the interesting point. We're going to look at the response of the Maharashtra Assembly at the end of this topic. Now, till then, let's get a grip on the issue as such. All right. So, what is the primary idea of parliamentary privileges? The idea is that freedom of speech and expression becomes excessively critical when it is exercised in the domains of parliament. All right, so all citizens in this country have a freedom of expression, right, which comes to them from Article 19 clause 1, right, but parliamentarians, it is deemed, have a duty to be excessively honest and very forthright in their deliberations in the parliament, and so you need a special privilege for parliamentarians to protect them from outside influences so that they could continue being as forthright and free in their expressions and in their deliberations in the parliament. So that's the idea. Now, the thing that you need to understand about privileges is that it's an exception to the rule of law. All right. Now, rule of law is the principle that all people in the land are subject to the same laws, and there is no higher being or a lower being in a constitutional sense, right? So, privileging some people over other, and in this case parliamentarians, sort of breaches that principle of rule of law, right? So it's a constitutional anomaly. All right, it's a constitutional anomaly. Now, the only thing that sort of justifies this anomaly is that parliamentarians need to exercise freedom of speech and expression without any fear of the executive or the judiciary. All right, so this is how the idea evolved in United Kingdom, right? It's enshrined in 1680s in the Bill of Rights, Article 9, which says that the parliamentarians have the power which reflect that the freedom of speech and debates and proceedings in parliament ought not to be impeached or questioned in any court or placed out of parliament, right? This is an important article, Article 9 of the Bill of Rights. If you mention this article, then it's going to add heft to your answer. All right, so you need to first establish the anomaly, all right, that it's an exception to the rule of law, and then you sort of need to write in one sentence or less that this is the source. The first fortification of privileges comes from Article 9 of the Bill of Rights. All right, and later on, the British Parliament excessively used this article under the Bill of Rights to impose penal consequences such as fines on outsiders as well as expulsion of its own members whenever they breach privilege. All right, so Parliament has used this to to impose fines on outsiders as well as its own members, as well as to keep the king's executive and king's courts outside Parliament, right? So there were many cases where a particular member of the House of Commons made a remark in the Parliament which was deemed worthy of a trial under high treason, right? That is committed the most seditious act possible. And in those cases, the Parliament sort of exerted its right that he had the freedom of speech and expression, right? So think about this, like the reason why this idea of breach of privileges becomes very important is when you think of all the things that parliamentarians can say in the parliament, right? For example, a parliamentarian could today walk into a parliament and say things like women do not deserve to be represented in parliament, or that people from particular communities or castes do not deserve to be represented in the parliament, or things of similar tone and tenor, right? And it would be he would be unscathed in the current constitutional scheme of things, right? That is the privilege to say whatever he wants. Now the idea feels more home, right? So think of the power that this privilege bestows upon the parliament and parliamentarians. All right. For example, you have your right of to freedom of speech and expression, right? That comes from Article 19(1)(a). However, your right is subject to many restrictions which are mentioned in the same article, right? But parliamentarians have their own privilege that they can say whatever they want, all right? So we're going to, now once you've understood the import of this, then you could sort of understand that most legislatures across the world would have needed such privileges. Article 1, Clause 6 of the US Constitution carries language similar to Article 9 of the Bill of Rights of the United Kingdom, all right? Then even the Government of India Act 1935 had a clause for privileges, right? Section 71 that pretty much said so. Now, when our constitution makers, our founding fathers, started discussing constitutional privileges in India, the first person that you must sort of take note of is H.V. Kamath, all right? He demanded on the floor of the Constituent Assembly that these privileges be codified. Why? So that we can make a clean break from the British precedent, right? Because in Britain, there is parliamentary sovereignty, right? Parliament is extremely powerful. So that extreme power suits their prerogative to define privileges as and when they please, right? The power to define your own privileges and your own immunities is quite a stark thing, right? It's quite blatant that we will tell you how much powerful we are, right? So the British Parliament could afford to have that position because they have something called parliamentary supremacy. But H.V. Kamath is saying that in India, we are not going to have parliamentary supremacy. We're going to have constitutional supremacy that somehow goes into the domain of popular sovereignty, all right? But Alladi Krishnaswamy Iyer and B.R. Ambedkar at that time gave two arguments as to why we cannot codify, right? So one, they said that the Speaker of the Parliament of the Constituent Assembly at that time had already tried to codify, and his conclusion was that it is impossible and not desirable to codify these privileges. Why? Because the schedule, if you include these privileges as a schedule in the Constitution, the bulky Constitution, the already bulky Constitution would get even more bulkier, all right? And Alladi Krishnaswamy then gave more substantive arguments for the same, but bulkiness was the primary reason why they thought that it's not necessary that they should specify all the privileges within the Constitution. Instead, they thought it perfect that the Parliament in future shall codify these privileges when they deem fit, all right? So that was the idea. Now, instead of excessively codifying, they settled on a particular article which is Article 105, all right? So it deals with powers and privileges of the Houses of Parliament, members and committees, all right? So privileges are exercised by the Houses in Union, all right, the members and committees of Parliament, all right? And we're going to go clause by clause for this article because this is a critical article of the Constitution, right? The reason why privileges is important is because it presents to you a constitutional anomaly. It's such an important topic in constitutional theory that there are more than 10 books dedicated only to this subject of parliamentary privileges in India, right? The topic is mentioned in your syllabus for GS2 verbatim, all right? So that's why we're going to delve deeper into this subject, all right? So clause 1 says that pretty much assures freedom of speech inside the legislature, right? So Article 19, which gives you the freedom of speech and expression, wasn't deemed sufficient. They had to have a separate clause within Article 105 to say that the people in the legislature are free to say whatever they want, all right? Then clause 2 explicitly, all right, it explicitly protects the act of speaking in parliament and to voting in parliament from judicial proceedings of any kind, all right? So important, right? For example, if you say something that is onerous or that is not deemed worthy, there could be a proceeding against you, right? Someone could say that there was some criminal element involved. That couldn't be done for a parliamentarian for either the act of his speaking or voting, and the voting part will become important later, all right? Then clause 2 further adds that there shall be no liability for publication of matters connected to the legislative business, provided the same is done under the authority of parliament. Now, you must have noted the speakers or the chairperson in Rajya Sabha or Lok Sabha often go, this is expunged from the record. This will not go on the record. There is no point speaking, right? So, the constitution says that if there's anything published under the authority of the speaker of the house, that publish the idea, like whatever is published will be protected from judicial scrutiny also, all right? Now, clause 3 is where the meat of constitutional theory sort of starts sinking in, right? Why? Because Clause 3 empowers the parliament to define its own powers, immunities and privileges, and this is, as I told you, quite a constitutional anomaly, right? So original clause 3 actually said that the parliament should have the same powers, privileges and immunities as that of the House of Commons. Alright, so then later it was deemed that we are not any more subservient to that nation. Why do we have references to that country in our constitution? So it was later said, it was later pretty much set straight in 1978. So the current form of this clause comes from a 1978 amendment, which said that as it was before the 44th amendment, right? There was another amendment, the 42nd amendment, which said that or as the privileges might evolve in the future, but that was deemed unworthy. And so we now have settled on this language, right? So clause 3 is important. Why is it important? Because it gives the parliament the power to decide its own powers, privileges and immunity. The thing that you should know next is that Article 194 does the same thing for state legislature, all right? Now, the thing that you must note, all right, take a note of, is that Article 105 Clause 3, according to Constitutional Assembly debates, was always deemed a transitory provision. Now, what does that mean? That means that the Constituent Assembly members were sure that Parliament in time would see reason in codifying its privileges, and until it does so, until it comes out with a legislation doing so, let's have a provision by the name of Article 105 Clause 3, because it gives Parliament to define its powers, right? The expectation is that it shall define its powers through a legislation, all right? So once you accept that it's a transitory provision, the privileges don't really stand on as firm a ground as they stand in the House of Commons, all right? Now, in India, some legislative privileges are expressly mentioned in the Constitution. We're going to do both of those expressly mentioned privileges. And then there are other privileges that sort of walk out of rules of procedure and conduct of business and Lok Sabha rules, all right? So the source of privileges is not just the Constitution. There are some conventions that offer privileges. There are some rules that offer privileges. And then Constitution itself specifies some privileges, right? So what are the privileges that are mentioned in the Constitution? The first one is freedom of speech. I've already clarified them, right? Article 105 Clause 1 and 105 Clause 2 enable members to express themselves freely in the House without any fear or favor. Now, the interesting thing about this is that as much as Article 105 sort of seem to indicate some sort of parliamentary supremacy, that they can do whatever they want within the confines of Parliament, we also have an Article 121 that actually says that the Parliament cannot discuss the conduct of a judge unless they are trying to remove him. right? The only way you can discuss the conduct of a judge in parliament is if you're impeaching him, right? So even though the standard of freedom of speech provided to parliament within the confines of the legislature is very high, Article 121 itself imposes this small limitation on them that they can't do anything with respect to a judge, all right? And Article 211 does the same for state legislatures, all right? So state high courts are involved there, right? Then the first part of Article 105 Clause 2 provides that there shall be no proceedings in any court in respect of anything said or any vote given to him. Now, most commentators say that anything here pretty much means everything, right? So, like, whatever they do with respect to a vote or whatever they've said is pretty much besides the powers of a court, right? This is what the commentators say, except, again, as I noted earlier, when they cannot discuss the conduct of a judge except when they are trying to remove him from his office, all right? So in parliament, again, is another limitation, right? So they can't really go outside the legislature and say things that pretty much violate the spirit of the constitution. They can only do that in parliament, all right? And so next move on, right? Then they have a right to publication of proceedings, right? Which comes from the second part of Article 105 Clause 2. This is an interesting one. Now, Feroz Gandhi at that time in 1950s understood the problems that might arise of parliament or legislatures using their powers in an unfettered manner. All right. And that is why he proposed a legislation, the Parliamentary Proceedings Protection of Publication Act of 1956. All right. So what does this legislation do? It says that there shall be no civil or criminal liability imposed upon an individual if he publishes a report based on the proceedings of the House and the report is, the wording here is, substantially true. All right. If the report that is published is substantially true, right, then there shall be no civil or criminal liability in any court, right? Now, unless it is proved that the publication of such proceedings was expressly ordered to be expunged by the speaker, right? So it should not be the case that the reporter reported it and the speaker said it's expunged, right? That would create problem. Now, Article 361A expressly sort of inserts this provision in the Constitution and pretty much lays down the principle, because this act was later taken off the books and then sort of later re-imposed on the books after the emergency. So this act has a very weird history, but Article 361A sort of fixes that. Now, there are some other legislative privileges that I've mentioned here that will feature in your notes. You could sort of go through these privileges. There are 11 of them. The idea is just to give you an idea that privileges arise not just from the Constitution, but from customs and traditions and rules of procedure and conduct of the House, right? So there are some other privileges also that you can look at now. So as I've already alluded to you, there seems to be a conflict between parliamentary privileges and fundamental rights, because Parliament has these privileges that they can exercise to violate others' fundamental rights, right? For example, if Parliament decides that they're going to jail you for saying that, then your fundamental right would be violated and their privilege would be upheld, right? So there's this inherent conflict in providing privileges to any class of persons. But once that privilege is also to sort of strike at your fundamental rights, then it becomes critical, right? And this is at the heart of one of the loudest, if not the loudest, one of the most important debates in constitutional theory in India. All right, fundamental rights versus privileges. The first case that you should take cognizance of in this matter, it was a case that was decided in 1958. All right, MSM Sharma versus Sri Krishna Sinha. You can write this case in your answers just MSM Sharma. All right, so the facts of the case, otherwise I would not have included them here, but the facts of the case is what would enable you to remember the case names. All right, because it's important that you must memorize also, and the facts are interesting in their own right. All right. So a member of the Bihar Legislative Assembly, in a speech, said that the chief minister is being dishonorable. Why? Because he has been listening to a former minister who is now no more minister because he's former, right? And he has appointed him the chairperson of a Khadi commission because he wanted him to retain his residence in Patna. And there were some very scathing comments, right? The speaker objected, the Bihar Assembly speaker objected, and as I told you earlier, his remarks were expunged from the record. Alright, his remarks were expunged from the record. Searchlight was a very famous newspaper at the time. These two, Blitz and Searchlight, and these were the newspapers of the day. A reporter there carried the entire report, right? What the member of Legislative Assembly had said, and he also carried the name of the former minister, right? Caused a lot of embarrassment to the chief minister, right? The chief minister sort of looked at the speaker of the Bihar Legislative Assembly as to, what are you doing? There's this guy embarrassing me in front of everyone, right? Then Assembly issued a notice of breach of privilege to the editor of Searchlight as well as the publisher, and the idea was that they published redacted remarks. The remarks had been expunged. How dare you publish them, right? So apprehending penal consequences, the editor approached the Supreme Court under writ jurisdiction. Right? This happened in stages, but eventually it ended up in the Supreme Court, right? Now, the petitioner's argument was that the exercise of legislative privileges and a consequent punishment would violate their freedom of speech under Article 19 and their personal liberty under Article 21, right? This was a simple argument. What is the argument? Privileges versus rights. Rights should be prime, right? Rights should matter more than privileges. What did the court held? The court held that you need to understand the context of this hearing, of this judgment. Recently we've become free. Most of the legislators have been freedom fighters, right? So there's this respect, there's this inherent respect for people in the assembly, and the court said the legislative privilege is supreme and it will subside the fundamental rights, right? So the court said that the legislature should retain control over such a publication to prevent what? To prevent inaccurate reporting or commentary that might cause hindrances to the functioning of the legislature, all right? And exercise of legislative privilege under Article 194 Clause 3 could trump the freedom of speech and expression under Article 19(1)(a), a very dangerous precedent, right? This would grant legislature the power to do pretty much like to trample upon anyone's freedom of speech, right? But the idea was the legislature would be very responsible in using this, right? Because in this case, there was a case to be made that the reporter actually reported on records that were expunged. All right. So you have to respect the legislature. Subba Rao gave a very famous dissent in that case. He's a very famous justice. He noted that it was a transitory provision, and once transitory provisions start trumping freedoms under Article 19, then where do we stand right now? All right. So that was the idea. All right. Then came the Keshav Singh case, or Special Reference 1 case. This happened in 1964. All right. The Speaker of Uttar Pradesh Legislative Assembly issued a notice for breach of privileges against one Keshav Singh, all right, who had circulated a pamphlet. Right? It was all about a pamphlet that criticized a serving legislature, right? So if a pamphlet is saying bad things about a legislator, the Speaker of the Uttar Pradesh Assembly somehow got involved, and he said, like, let's issue a contempt notice against him, right? And on the same day, an arrest warrant was also issued because the Speaker said that the letter that Keshav Singh had written to him responding to this contempt notice was also very disrespectful. So he issued an arrest warrant and he was detained in a district jail for 7 days, all right? Then a habeas corpus writ was filed in the Lucknow bench of the Allahabad High Court, right? And the two judges, right, N.U. Beg and G.D. Sehgal, the reason I'm mentioning these judges is important, all right? So what they did was, they heard the matter and directed the detainees released. They said, the judges said, please release the poor guy. He didn't really do as much as you think he did. Then the assembly responded aggressively. All right. They issued fresh notice of breach against the two judges. the accused, Keshav Singh, and his lawyer, right? 4 people were now under the scanner, right? Under the legislature scanner, right? Then parties approached the Allahabad High Court. All 28 judges of the Allahabad High Court sat together and decided that this was quite a heated topic at that time, right? So all 28 judges sat and they said, let's issue an interim order that restrains the assembly from acting on the order of arrest until we decide whether this order is constitutional or not. All right. Now, as this was escalating further and further, this unprecedented situation was diffused because big people got in, right? Like the seniors of the house and the seniors of the government sort of entered and said, okay, let's just like calm this down, right? Let's calm everything down. And then they pretty much said that, okay, we are revoking, the legislature sort of revoked the arrest warrant against the 2 judges and Keshav Singh's lawyer. Nevertheless, the government recognized that this is a critical area of law, right? The parliament or the legislatures have been given this power and they might use this again, and this might come up again. That is why the union government sought an advisory opinion from the Supreme Court under Article 143 Clause 1. Right? Which is why this is called the Special Reference 1 case. All right. And in the Special Reference 1 case, the Supreme Court held that Indian legislatures cannot issue warrants to preclude the jurisdiction of the courts. They can do a lot of things, but they cannot be a warrant that says that the courts are not involved now. Right? You cannot exclude the jurisdiction of the courts. That should not what the warrant should say. All right. And this is the meat of the matter. All right. In Special Reference 1, the Supreme Court held that Indian legislatures cannot issue general warrants to preclude the jurisdiction of the courts. Such a privilege would be inconsistent with what? Articles 32 and 226 of the Constitution, which have invested the Supreme Court and High Courts respectively with the power to protect fundamental rights. Now, Gajendra Gadkar, who was a very famous judge of the Supreme Court at that time, made some thundering remarks, right? And you could use some parts of this language in your answer, right? What does Gajendra Gadkar say? He said the rights of citizens to move the judicature and the rights of the advocates to assist in the process must remain uncontrolled by Article 194 Clause 3. All right. So you sort of understood this, right? So Gajendra Gadkar's another argument was again what we've discussed earlier, right? He said, just as there are restrictions on judiciary discussing things about parliament, similarly, there are restrictions upon parliament discussing things about judiciary also, right? Articles 121 and 211, right? They bar the legislatures from discussing judicial conduct unless they are removing a judge, right? So Gajendra Gadkar said there is a scheme of separation of powers in the Constitution, and legislature does not have the power to simply say that the courts will not do their job, right? So that's an important part that Gajendra Gadkar highlighted. But what do these facts highlight to you, right? What comes out of these facts? The facts sort of indicate to you that legislature sometimes has powers that they can use to imprison people without giving them a fair hearing, and it could curtail the rights under Article 19 and more importantly under 21, right? Personal liberty. If people are detained and kept in a jail for 7 days, for a month, right? Then it's personal liberty also that's involved, right? So you could see the evolution of Supreme Court's arguments, right? In 1958, the court is like, oh, these freedom fighters, they must have the wisdom necessary. Let's go by the constitutional scheme. But in 1967, the court is like, okay, Parliament's power is not all that supreme. Article 32 and 226 hold importance as well. All right. So now you've understood the dilemma over fundamental rights versus privileges in the Constitution. Now let's come to the corruption part of it. How are privileges associated with corruption? All right. So the case that sort of stands out in the constitutional history of India is PV Narsimha Rao versus State. All right. In this, the petitioner was the Prime Minister of India, the PV Narsimha Rao. All right. So what happened was, this was quite a terrifying time in Indian politics and Indian Indian society. In 1993, the Ram Janmabhoomi movement was at its peak, and the reservations in the Mandal Commission Ayog reports were making quite a noise. And at this hour, there was a no confidence motion against the Narsimha Rao government. The Narsimha Rao government somehow barely won the vote, and later it emerged, the CBI thought, or it was with the information was with CBI, that the Prime Minister and some of his colleagues had bribed whom? Some other parties to vote in the favor of the government, right? So Jharkhand Mukti Morcha and such parties, all right? So CBI wanted to initiate proceedings, but it needed what? It needed sanction, all right? It needed sanction of the executive. So the case turned up in Supreme Court, right? And the question in front of the Supreme Court was whether these people should be prosecuted or not. What did the Supreme Court conclude? It's again a scintillating conversation that exists between at this hour in the Supreme Court, all right? The Supreme Court says that legislators could not be prosecuted because Article 105 Clause 2, as I have told you again and again, specifically protects the speech of legislators and their act of voting. Alright, it specifically protects them. So even if they've taken money, even if it later turns out that they've taken money, they are protected by their privileges, all right? And then the Supreme Court drew a distinction between bribe givers and bribe takers. They said those people who have bribed, who've actually given the bribes, and who are not legislators, can be subject to prosecution, prosecute them. But those people who've taken the bribes and voted in Parliament, because it's an act of voting which shields them from prosecution, and those legislators who have taken money and not voted in Parliament can also be prosecuted. Now, this was this created quite a storm in India's legal, political, and constitutional circles. Right? So based on this case, this was deemed so outrageous by many people that the National Commission to review the working of the Constitution, the Venkatachalaya Commission, actually carried this note that it's time to explicitly exclude corrupt acts from its ambit and codify some of those privileges, right? You must come across these recommendations every now and then, like Venkatachalaya Commission said this, the commission said that. This is an important one, all right? Then Faizan Mustafa, in a classic article written in 2017, now in 2017 what had happened was that the Karnataka legislature under H.D. Devagowda had put some people in jail. All right, some new journalists in jail on account of some reports that they had made, which had implicated some legislators in some wrongdoing. All right, so Faizan Mustafa used the opportunity to argue a few things. First thing that he argued is that the constitutional makers were not very cognizant or were not right in their in the way they defined constitutional privileges in India, or the fact that they refused to define constitutional privileges in India. Why? Because he said our model is based on House of Commons, where House of Commons has the power to define its privileges. That's why we've also given Parliament the power to define their own privileges. But we have parliamentary sovereignty in House of Commons in England, but we don't have parliamentary sovereignty here. Right, so it doesn't fit, right? So if there's constitutional sovereignty. Now, because there is constitutional sovereignty, which sort of straddles into popular sovereignty, Parliament does not get to define its own privileges, and it was a transitory provision even if Parliament was to define, right? So that is Faizan Mustafa's argument, all right? Then there is a question that are parliamentary privileges sort of relevant now, right? Because House of Commons does not use at least its penal powers, right? It doesn't send people to jail for comments that they've made in a newspaper, right? Then the US House of Representatives Privilege Committee does not have privilege powers, and their functioning has been pretty smooth, right? Australia also saw the problem, and in 1987 they codified their privileges. And these new constitutions, right, that have come up in the 80s and 90s have all codified their privileges either within the Constitution or outside the Constitution. And even our own provision, most commentators, especially H.M. Sirvai, right, in the special reference case, we had a legendary battle between H.M. Sirvai and M.C. Setalvad. The M.C. Setalvad, who was the first Attorney General of India, and H.M. Sirvai, the foremost constitutional authority of India. And H.M. Sirvai pretty much said this is a transitory provision. All right. So I hope now that you come across a a topic on privileges, whatever you read on privileges, you'll have a fair idea as to what's happening. All right. Now, what did the Maharashtra Assembly say? The Maharashtra Assembly, now think amidst all this background, right? The Maharashtra Assembly said that we are not going to respond to the notice of the Supreme Court. Why? Because it might allude to the fact that we are subject to their jurisdiction. We are not subject to their jurisdiction. We have our own rights which come from, we have our own privileges which come from Article 105, and in this case under Article 194 of the Constitution, the Supreme Court doesn't have a say, right? And this contradicts what? This contradicts the special reference case, right? It contradicts MSM Sharma, right? Because in MSM Sharma, it was clear, this contradicts Keshav Singh case. In Keshav Singh case, it was clear that Supreme Court's powers under Article 232 and 226 are valid, right? They both can exist simultaneously, right? So that's the interesting bit. That's why I sort of wanted to bring out this topic, all right? So let's move on. What's the next topic? The next topic is who gets to decide when parliament sessions occur and what's the status right now. All right. So why do we have this in news? Because Lok Sabha, the Congress leadership in Lok Sabha, and the leader is Adhir Ranjan Chaudhary. He sort of small, like a short parliamentary session to discuss agricultural laws, right? Let's convene in Delhi and let's discuss and debate for a week, right? But Prahlad Joshi, who is the Parliamentary Affairs Minister, he said that some opposition parties have expressed concerns about the ongoing pandemic, and they have opined that let's do away with the winter session, right? So this has again created this sort of conversation around who gets to decide when when sessions occur and when they don't occur, right? So let's get into that right away, all right? So the power to convene a session of parliament rests with the government, all right? The executive has power to convene a parliament, which is a critical detail in constitutional theory, right? Ideally, the parliament should decide when they convene, right? And it does. But what happens is that because we have this linkages, right? We have interdependence of executive and parliament. So executive in our case actually decides when the parliament will convene, right? The decision is actually taken by the Cabinet Committee on Parliamentary Affairs, and this Cabinet Committee on Parliamentary Affairs sort of includes Defense Minister, Home Minister, Finance Minister, Law Minister, and a bunch of other ministers. 9 to 10 ministers sort of come together and decide when a session is to be called and when a session is not to be called, right? Then the decision of the committee is then formalized in the name of the president, because the session is called in the name of the president, all right? What is the current scheme of things? You need to write that we don't have a fixed parliamentary calendar, right? By convention, what is the convention? That parliament meets for 3 sessions in a year, all right? The longest is the budget session, which starts towards the end of January and concludes by the end of April or the first week of May. So the longest session is the budget session, which has a small break, right? Which has a small break. And if you've understood the process by which bills are passed, that the budget is passed, you would know why there is a break also. And if you haven't understood, you could do them later on, all right? So then the session has a recess and budgetary provisions are discussed. Then the second session is actually a 3-week monsoon session, all right? Which takes place in July and August, all right? Then there is a winter session, which should be happening right now, November, December, sort of, again, 3-4 week winter session, all right? Now, what are the constitutional provisions in this regard? There's an Article 85 that pretty much says 2 things, right? The president has the power to decide at what time the parliament has to be convened, at what place the parliament is to be convened, and the fact that it sort of lays down a restriction that there should not be a gap of more than 6 months between 2 sessions, all right? That's what it says, right? Then the corresponding provision in Government of India Act was there was a corresponding provision in the Government of India Act, and what it said was that the parliament shall meet every year and there shall not be a gap of 12 months, more than 12 months, right? So the wisdom at the time of drafting of the constitution was that this provision under Government of India Act just made Parliament collectors of revenue, right? Because they would convene in New Delhi, the central legislature at that time, and they would sort of say, okay, this tax is to be collected, this tax is to be collected, this tax is to be collected, and they would go back home, right? They became this overlord tax collector of sorts, all right? And because they never met otherwise, there was no check upon the government, right? There was no check upon the government. So, at that time, the discussions of the Constitutional Assembly, you sort of come across this insane amount of faith that the constitutional drafters have, especially B.R. Ambedkar, on the future generations of the country, right? He says that the problem later will not be the fact that the Parliament is not meeting enough. It will actually be that the Parliament is meeting so often that the parliamentarians are getting tired of these sessions, right? And maybe he's sort of drawing his inspiration for these comments from the fact that Constituent Assembly was meeting alternatively as a national legislature for the country also, right? Maybe that's where it's coming from. But think of the faith he has in us, right? So that's the idea. But during the assembly debates, what happened was there was a debate like how many sessions should we have, how many days should the parliament sit, and who should convene the parliament, right? So Professor K.T. Shah, right? He was called Professor G in parliament also. He's quite a senior figure. He's from Bihar, all right? So Professor K.T. Shah at that time, who was a member in the Constituent Assembly, he suggests that the parliament should sit throughout the year and should have some breaks in between, all right? And that under certain circumstances, the presiding officers of the houses should have the power to convene parliament or legislatures, right? And there are others who sort of want the parliament to sit for longer hours, right? This 6-month gap will become a 6-month gap. So please, let's sit for longer hours, as the British House of Commons does or as the American Congress does, right? But these suggestions were discarded, and instead we have these flexible sort of date structure, all right? So this flexible date structure has always been used by governments of the past, all right? It's always been the case that the timings of the sessions have been sort of moved around, right? During the 2008 nuclear deal issue, the session was shortened and sort of moved around only because they expected a no confidence motion in the future, all right? And whenever there are state assembly elections, both opposition and the government sort of get together and decide, okay, let's move on. We'll have a session later, right? So these sessions have always been moved around, but because in this particular year the parliament has only sat for around 33-35 days, that's why there is a conversation about decline of parliament that has set in, all right? So Chakshu Roy of the PRS, he says that, so he just points out some figures that during the first 2 decades of parliament, Lok Sabha met for an average of little more than 120 days a year, right? That was the stature. 4 months a year they're in Delhi and discussing stuff, right? Now it's approximately 70 days. In the past decade, the average is 70 days. So the parliament is not meeting as often. Now, one reason as to why this has happened is some people say is because of the standing committees. Now, most of the work actually gets done in parliament through standing committees. So you should not read as much into the number of days parliament is sitting or not. But at the same time, several committees have sort of recommended that parliament should meet at least 120 days a year, right? That's their job, right? So this year, parliament has met for 33 days, and the last time it met for fewer than 50 days was in 2008 when it met for 46 days, right? So this is a pandemic year. Maybe that's how you could excuse some of this thing that's happening, right? But otherwise, House of Commons meets regularly. They have come up with procedures on how to do it, right? There are some, in fact, House of Commons actually gave money to the legislature so that they could install equipment necessary to be present in parliament without being present in parliament, right? But how they could just appear on screens and stuff, right? So there was actually a lot of investment that went into upgrading the infrastructure of parliament in establishing these direct links, so that the parliament could function, right? Houses of Congress are meeting right now, discussing a deal to sort of come out with a package in the post-pandemic era, right, to sort of economically stimulate the people, right? And other parliaments are meeting also, right? So why do we have to restrain the number of days that we meet, all right? Then comes the topic of limitation. Now, let me give you a disclaimer right away. We're not going to do this in detail. Why? We're going to wait. So what has happened is that there is a Pranab Mukherjee Foundation that has come out with this interesting idea that the next delimitation should actually take place in accordance with 2031 census, all right? So it's frozen in 1971, so it should take place according to 2031 census, whenever the next delimitation takes place. We are expecting an informed conversation in the newspapers. All right, it hasn't happened up till now because the comment has just been made, and as soon as an informed conversation in the newspapers begin, we will have some new arguments, some new nuances to sort of look at, right? So let's wait for that. Up till then, all you need to do is that you should know what a delimitation is, right? It's an act or process of fixing limits or boundaries of territorial constituencies in a country. To bring out how critical delimitation can be, there are jurisdictions across the world. In Pakistan, for example, the most constant allegation against the election commission there is that the delimitation process itself is fraudulent, right? The constituencies are created in a way so that one particular party can win, and this is called gerrymandering, a process in United States, right? Europe doesn't have these problems. But think, like, if someone in charge of the delimitation process favored a particular party, he could create constituencies in a way to ensure that only one party wins, right? So that's how critical it is. So we must have come up with a fairly foolproof structure to deal with it, right? So Delimitation Commission is appointed by the president, right? It works in collaboration with the Election Commission of India. There's a retired Supreme Court judge on it. There's an election commissioner on it, and there are representatives of state election commissions. Currently, the 84th Amendment to the Constitution, which came in 2002, has frozen the delimitation of Lok Sabha and State Assembly constituencies till the first census after 2026. What is the first census after 2026? 2031, right? So, and up till then, what the decision that we've taken is that we're going to decide which state gets how many seats in accordance with the 1971 census. Why was it done? Because when Indira Gandhi came to power, she sort of made this brave push to limit the number of Indians that exist, right? At that time, the population was sort of soaring above 50 crores. So Indira Gandhi got worried and she pushed a huge family reform plan, and what happened later was that the southern states sort of did well on that count and the northern states did not. So the southern states sort of had this anxiety that if the number of seats that each state gets defined by the number of, or is a representation of the number of people that they have in their state, by that logic we should reproduce more, right? But Indira Gandhi didn't want that, so she did not want to disincentivize good performance on family planning indicators, right? So informally it's called the Great MGR Accord, right? The Indira Gandhi MGR Accord, MGR who was the chief minister of Tamil Nadu at that time, but don't use that in your answers, right? It's not in formal term or such. It's not used by commentators as such. All right. And so there was this accord, and according to that, the census delimitations were sort of frozen in 1971. So we had a census, we had a delimitation act after the first census, after the second census, after the third census also. But then we decided that we're going to freeze it till then. All right. So the delimitation within state assembly sort of happens in accordance to 2001 census. The delimitation for the Jammu and Kashmir polls happened according to the 2011 census. All right. So wait for like a good conversation to sort of spring up. We're going to do this historically. We're going to do the problem of delimitation. How was it decided that we're going to do the way we did parliamentary privileges? We're going to do delimitation that way. All right. So don't fret about it. And I hope you're listening. I hope you're reading your newspapers properly. I hope you paid sufficient attention to this class also. All right. So thank you so much for listening. Take care of yourself and study well. Bye-bye.